Hello, everybody. My name is Matthew Beatis. I'm an associate here at WOLFSDORF Rosenthal, and today I'm going to be just giving you a rundown of the O-1A visa for individuals with extraordinary ability in science, education, business, or athletics. Um, Before we get going, I just want to stress that this is just for general information purposes. All these visa applications and cases are highly particular, and you're going to want to contact and talk to an experienced immigration attorney about your case. I'm happy to answer general questions, but for specific questions, please do feel free to contact me at the conclusion of the webinar. So to start, as I said, the O-1A visa is for individuals of extraordinary ability, and today we'll be specifically talking about extraordinary ability in the sciences, education, business, or athletics. The first key aspect for these O-1A visa applications is that, as with many other non-immigrant visa applications, it is an employer-dependent application. That means you must be sponsored, or there must be a petitioner that's sponsoring you to come to the U.S. to work in some kind of role. You cannot self-petition. And then you must be, of course, as the name of the visa indicates, you must be an individual of extraordinary ability in a specified field of the sciences, education, business, or athletics. So it is quite broad. The O-1 visa is a temporary non-immigrant visa. Its initial validity can be for up to 3 years, and then it can actually be extended in either 1 year or 3 year increments afterwards. But it can also be renewed or extended indefinitely as many times as you can still show that there is still work in your field and that you still have a non-immigrant intent and you intend to depart the United States eventually and you don't intend to live here forever. One very important aspect also of the application is that you you will need an advisory opinion from a peer group, peer who would be considered to be an expert in the field, or an appropriate labor organization if one exists. If there's no appropriate labor organization that exists, you can just get a written advisory opinion from a peer or a peer group or a well-known institution in your field. So what does extraordinary ability actually mean? Often people will think that it means that you must be famous or be a celebrity in order to get the visa, and this is just not the case. The legal definition that we use is that extraordinary ability in the field of science, education, business, or athletics means a level of expertise in, indicating that the person is one of the small percentage who have arisen to the very top of the field of endeavor. I personally think that that legal definition still makes it sound like you must be a famous celebrity or one of the most famous people in your field in order to qualify, which I believe is not the case. Really, what ends up happening is you must demonstrate at least 3 criteria out of about 8. Of course, if you do have one outstanding one-time achievement, a world-famous award, a Nobel Prize, for instance, then that's all you do need. But often, a vast majority of the people don't have a Nobel Prize, so we can satisfy all the other criteria to show that an individual has reached the level of extraordinary ability. And as this slide notes, really what we're trying to show is that you have reached a level in your career where you have a sustained national or international acclaim and you have recognition in the field for your expertise, for your skills, for all your achievements. So as I just noted, a receipt of a major internationally recognized award, such as a Nobel Prize, that will do it. That should be that's really nice to get, and it'd be great if someone has a Nobel Prize. But if we don't have a Nobel Prize or some other equally famous major award, then we can look to other criteria. So what I'll do now is just go through each of the criteria and kind of explain them, and if any questions come up, I can try to answer those. So the first criteria would be lesser awards. Any documentation of any, quote, lesser nationally or internationally recognized prize or award for excellence in the field of endeavor. Often, this may be an award that an individual you may not think is a big deal, but as long as we can show that the award does have prominence in the field, it's recognized either in your country or across the country as being an important award for your field, this can be used to show receipt of a lesser award. We've also had situations where even if a project that you're on has won a major award, if we can show that you are intricately tied to that award, it can be used as proof of receipt of some kind of lesser award. Memberships, documentation of the alien's membership in associations in the field for which classification is sought, and it goes on. So membership in some kind of relevant organization that's in your field. I've worked with people before who are public relations specialists and are in that organization, the professional organization. There's many other examples as well. The key here, though, is that you can't, membership alone isn't sufficient to satisfy this criteria. You need to show that the membership is only achieved through the proof of your outstanding achievements in the field. And so there needs to be some kind of baseline criteria that shows that in order to get into this professional organization or association, that you need to be of a certain stature in the field. There needs to be some kind of vetting process. So if you can do that, then it's something easy, in my opinion, to get done and use as evidence of proof in a professional membership. Press. So this is more or less straightforward. If there's any published material in either professional or major trade publications about you relating to your work, then you can satisfy this third criteria. Importantly, the big deal here, though, that the government likes to really pick on is major media. What qualifies as major media? Is a website considered major media? Is a blog considered major media? And the answer is it can be. Often, though, we'll have to go in and kind of look at the reputation of the media source, as well as, if it's a blog, how many hits does it get, and this kind of thing. Of course, if you're in a trade journal or a trade magazine, or if you publish articles in a major journal, then this is easy to satisfy. A lot of the people in the sciences or education may have articles already published, and that makes our job really easy. For business professionals, it can be quite a bit harder because often there's not a whole lot of information or publications out there about the kind of stuff you've done. Maybe it's a smaller, like I said before, a smaller blog has written about something you've done, and then we have to argue whether or not that is a major media. But it is possible. We've done this before, and it can be argued very well. Number 4 is whether or not you've judged the work of others. So you've served on a panel or individually as a judge of the work of others in your field. Again, though, in adjudication, this gets a little bit more complicated because the government likes to see that not only were you a judge, but how were these judges selected? Who are the other judges? Do you have to have some kind of specialty or specialization? Or be well known in order to be selected, and that it can be very hard to prove. We need often a letter from the competition showing or explaining how the person became a judge and everything like this. That brings us to the next criteria, which is significant contributions, and this is any evidence that you've made original, scientific, scholarly, or business-related contributions of major significance in the field. This one can also be a little bit broadly applied. The ideal situation is that you own your name is on some sort of patent that's out there and it's easily proved, and we can just submit evidence that the patent has been submitted and you made some kind of invention. Of course, that's the rarer case and is more easily said than done. Other things that we would often look to satisfy this criteria includes any kind of process or methodology that you may have had participation in developing. If you've written any kind of guides that are available that can be submitted or anything like that. That's the kind of the second tier way to establish the significant contributions. Lastly, we might say that through the body of your work, if you have had lots of success in doing different sorts of projects, we could try to make an argument that your entire career body of work by itself is a significant contribution to the field, and you push the field in some way, shape, or form into new areas or into experimenting with new ways of doing things. That's the most indirect way of trying to go about it, but it's something that we've done before and to some moderate success. Criteria number 6 is publications. So this would be your publication, not press about you, but publications that you've actually authored. Again, you have that language about major media, and we can argue all day about what constitutes major media. Our general, or my general rule is that the more the better, and no matter how little something seems, we can always look into it and see how it may be considered major media. Not maybe if it's not major media to the public, it could still be major media in your field or in within your field in your country or something like that. So anything that you can really come up with in terms of publications that you've authored can often really help our cause. Criteria 7 is critical or essential roles, which includes evidence that you have played a critical or essential role for organizations and establishments that have a distinguished reputation. So as you can tell, there's two aspects of this criteria. One is that you've played a critical or essential role for an organization, and then 2 is that that organization has a distinguished reputation. Both of these aspects can be interpreted broadly. Usually for critical or essential role, we kind of look to see what your title was in that organization. Were you a manager? Were you a project leader? What were you actually doing for the organization or establishment? And then in order to prove distinguished reputation, we have to go and look and see what is this organization, what have they done, what awards has the organization won, is it well known, this kind of thing. So, and again, an organization may not be world famous, but it could be well known in your field or even in your own country for a specific specialty. Often we'll look for press about the organization or anything like that. So that brings us to that one. And then lastly, or penultimately, we have information on high remuneration, evidence that you've commanded or will command a high salary relative to others in your field. This criteria often throws people off a little bit because they think, oh, I haven't made a ton of money, so I probably don't satisfy this criteria. But often we're able to prove this because we look both to average salaries across the entire United States as well as average salaries for people in your field, specifically in the geographic region where you intend to work. And often applicants, without even really thinking about it, will end up in the top 20 or top 10% of salary of people who in the field salary-wise without even really thinking about it. We have to call upon wage surveys that are published by the Department of Labor in order to prove this. So we typically ask people to provide either tax returns or pay statements or other things like this to show that they've had high remuneration recently. Or we can even use, depending on what your proffered role is in the U.S., we could use a job offer here in the U.S. to show that you will be making a high salary compared to others in your field, and even more specifically compared to others in your field in the geographic region which you plan on working. Lastly, the government does allow us to submit comparable evidence if none of the, or if any of the above criteria we've already discussed do not apply to you and your profession. So this can happen a lot of times with business professionals because a lot of times business professionals will be behind the scenes people. They're not the CEO, but they've helped a major company either make a lot of money or save a lot of money, and they've had a history of doing this for many years. So there's not going to be press about them, and they're not going to win any awards because that just doesn't happen in the business world. So we say, USCIS, there's these awards. An individual like Mr. So-and-so is not going to win awards for his job as a project manager, and he's not going to be written about. But he's helped his company make $100 million or 100 million euros over the course of the past 5 years. Please look at all of these expert testimonies from people who know him. Everyone clearly says that he is an expert in the field, has pioneered project management, something like this, and he's very, very well deserving of classification as an individual of extraordinary ability. And that can work. So the key thing there is to make sure that we are actually able to prove that at least one of the criteria do not fit you in your field, either your field generally or you in your career specifically. And then usually what we'll do is we'll, as comparable evidence, we'll try to submit as many expert opinion letters or reference letters that really rave about you and how impressive you are, and how it's widely known that your reputation in the field is of the highest caliber. And that can be used to satisfy the comparable evidence criteria. So of those 9 or 8 plus the comparable evidence criteria, you need to satisfy 3 in order to qualify for the O-1 visa. Typically, I personally feel most comfortable filing a case if I could make strong arguments for at least 4 or 5 of the criteria. I think making obviously if you can only satisfy 3 and there's no other arguments to be made, then you can go forward. But I personally feel most comfortable having a little bit of breathing room because the government, all of these things are pretty subjective. Even something like high remuneration, which seems like it should be pretty cut and dry. The government can dispute that you're not really the highest paid person in your field. Even if you have evidence showing that you're in the top 1% of the field, they could say it's still not the highest. So it's good to have breathing room. So if the government disputes one and we really can't prove at least one of these criteria is satisfied by our arguments, then there's at least 2 or 3 other strong arguments we make for other criteria. So again, I think you want to really shoot for around at least 5 of the criteria to be satisfied, to be comfortable in having a strong case. So, and then one other thing to really understand about all of these criteria is that beyond just knowing that you satisfy it and saying in a letter or in a support letter that you're able to satisfy it, you really do need to submit hard documentary evidence showing that you've satisfied the criteria. So this often happens, it becomes a problem with awards, because a lot of times, especially again in the business world, you'll have won an award, but there's not really a lot of whole documentation showing that you won the award or what the award is. Maybe a team you were on won an award, and the team won an award, but your name's not tied to it. So then how do you go about proving this? And then we have to get creative and say, okay, can we get a former employer who oversaw the team to write a letter saying that you won the award, that the team won the award, and you were a key member of the team? Can we have the organization who granted the award write a letter confirming that you won this award or something like this? Just one example. All the other criteria too, that we really need to submit as much paper as possible, really showing that you satisfy all the criteria. Another important piece of paper that needs to be generated is some kind of either deal memo or agency agreement or contract showing that you actually have a job. And this is something that the government likes to pick on. I've had issues recently where we get requests for evidence saying that you provided a deal memo, but we really need something that's signed and countersigned, signed by the employer and countersigned by the beneficiary. So it's important to have some kind of actually properly executed deal memo or job offer letter or contract set up as and included as part of the application packet. Itineraries are often requested. This may be something that often for athletes will come up. Typically for people in business and sciences and education, more often than not, you're not really going to have an itinerary because you're going to be working for a single organization or institution, either for a temporary 1, 2, 3 year period or just, on an at-will basis. And that's fine. That works. If you have a contract or agreement just saying that, from a business or from a university or anything like this, saying that you're going to be employed by the organization, for an indefinite temporary period, that should be fine to cover everything, and you don't need a specific itinerary saying you're going to be doing X, Y, and Z from this date to this date, et cetera, et cetera. However, for other people who do not have this kind of scenario, who have either, they're coming over as an athlete, or they don't have one regular employment scenario, then they will need to provide a detailed itinerary with the dates of each event or activity, where the event's going to happen, all this kind of stuff. So once we get all of that documentation, then we can start to put together a visa application. These applications can be put together basically as quickly as we're able to get all the needed documentation. Typically, I think that takes between 1 month to 3 months, depending on how well the individual is able to get everything together and get all the needed reference letters and contracts and all this kind of stuff. Then the question often is, okay, once the application is put together, how long does it take to file, or for it to be processed? And that varies depending upon where you're located, where the application's filed, and whether or not you want to participate in the premium processing service that the government offers. If you're anywhere on the East Coast or closer to the East Coast, and you can get a whole list of the states that this applies to, you'll be applying at the Vermont Service Center. At the Vermont Service Center, the processing time frame right now is they're working on applications that were filed on November 9th, 2015. So that brings us to about 4 months if you file it right now. In the California Service Center, for people who live on the western part of the United States, they report that they can process and adjudicate these applications within 2 weeks. What's important to realize is that these timeframes are not solid. They fluctuate, and the government is not bound to them. So the California Service Center says 2 weeks or less. From my experience, it could be 2 weeks, could be 4 weeks, could be 6 weeks. It's really hard to determine. You can check the processing time, by visiting the USCIS website, and they're updated pretty regularly, but again, you really can't rely on them. If you're in a situation where you really need certainty and are on a more compressed time span, you are able to use the USCIS Premium Processing Service, which would guarantee adjudication or processing within 15 calendar days of filing. All this means, though, is that you'll get an initial adjudication within 15 days. It could be approved, or they could request more evidence within that 15-day period. However, if you use premium processing and a request for evidence is issued, when you respond to the request for evidence, they will then give you a final adjudication within 15 days of responding to the request for evidence. So everything is speeded up considerably. The downside of using premium processing service is that it is an additional $1,225, so your cost is going to go up a bit. Right now, I'm advising all of my clients that if they're able to use premium processing service, they should just use premium processing service from the beginning. I've had situations recently where we thought we were going to have a 2-week turnaround, and 2 weeks turned into 2.5, 3 months very quickly, and then we upgraded to premium processing, and at that point, you've already wasted 3 months, and then you're out $1,200 regardless. So my general advice is, if you have the money and you're able to, right now I would say just spring for the premium processing regardless. it is more money, but it'll give you peace of mind, and you'll have a much quicker response, and you'll know what your situation is. So that brings me to the end of the general presentation. I'm happy to answer any questions that might come up. I'll hang around for a few minutes to see if anyone types in any questions. Other than that, it's been a pleasure to explain the O-1A process to you. And I'm happy to answer any individual specific questions that people might have if you want to email me at my mbeatus@wolfsdorf.com address. So Michael asks, so if, for example, a project manager only has 2 out of the 8 criteria but has several expert opinion letters, is it even worth applying since you won't meet for the 4 or 5? It's a good question. You know, it depends on your specific situation. You know, it's a very general, that's a general comment, right? I'd like to see, what 2 criteria do you satisfy? What kind of evidence do you have that you're able to satisfy it? If we know for a fact that it looks like 99% chance you're going to be able to satisfy at least 2, then, we can talk about, okay, then we're going to make the argument that at least one of these other criteria don't apply to you, and then we're going to submit 10 or 15 expert opinion letters. Then my question is, okay, who are these expert opinion letters from? What's their background, and how much weight are they going to carry? The government loves expert opinion letters from people who are professors at universities. So can you get like someone who's a professor, an MBA professor from a pretty well-known university to write you a letter saying how, in his opinion, in his or her expert opinion, that you are one of the best at what you do? Then at that point, it's up to the client, up to you as the client, and also, your petitioner. How confident do you feel you're investing money, time and money into the legal fees and filing fees? It's whether or not it's worthwhile to file is how comfortable you feel in the risks. How comfortable you feel in the risk that the money you're investing into this application process might end up leading to a denial. My practice is to never file a case unless I am confident that it has a good to really good chance of being approved. So once I would analyze the specifics, I would shoot you straight and say, I think we have a good chance of getting approval, or if I don't think we're going to have a good chance of approval, I will let you know and say, honestly, I don't think it's worthwhile moving forward. So that's my answer to that question. I'd be very happy to speak with you more about the specifics of your case if you want to contact me after the webinar. What agency, union, labor organization may issue a consultation letter for a business person? To my knowledge, there actually isn't one, which is why often we will then rely upon a peer or peer group to do the advisory opinion for that, and I haven't had any problems doing that. Often I'll get, like I just mentioned about the expert opinion letters, we'll get a professor who teaches either teaches an MBA course or something like that to write a letter saying how this person is well known and how it is appropriate for him or her to have the extraordinary ability classification. So Michael came back and asked, so I think going back to his first question, so possible, probably less likely, but depends. Yeah, the short answer is yeah. It depends on the specifics of your situation and how comfortable you are with the risk. I'll hang out for a few more minutes to see if any other questions come up. last questions from Michael. Can an agent bring an artist under the O-1 to look for work, or do the gigs already have to be lined up? Um, the short answer is for an artist, there definitely needs to be at least some gigs lined up, because so we're talking about the O-1A today, which is for business people, people in education, sciences, and business. Artists would fall under the O-1B category, who has very, very similar but some different criteria. But for artists under the O-1B that are coming in as sponsored by an agent, they are definitely going to need an itinerary, and the itinerary needs to have gigs on it that are real gigs. We'll always then support the itinerary with hopefully contracts. If not contracts, then at the very least engagement letters that from wherever the gig is going to be, the promoter, the venue, whatever, saying we are going to have a show for Mr. or Mrs. So-and-so. They're going to do a show on this date at this time. The tricky part with the artist, I know it's one of those things where it's not very realistic to have an artist have gigs lined up 3 years from now, and that's kind of the challenge, right? So what we often do is we see if there's any venue that where the artist is currently in contact with that is willing to say, at least tentatively, there are gigs lined up in the spring of 2016, in the fall of 2017, and the summer of 2018. And that's the best they can do. We don't. There's no contract that's going to say that an artist is doing a gig in 3 years. So you kind of have to do the best you can. But the short answer to your question is yes. At least some gigs need to be already lined up. Otherwise, the application won't get approved. But of course, you can add gigs after the person does get here in the O1 as well. Okay, well, I'll hang out for one more minute to see if any questions come up. And if not, then I hope you all have a great afternoon. And again, please don't hesitate to contact either myself or anyone from our firm if you have any specific questions. We love doing these O-1 applications. The people, oh, we had another question. Is it possible to transition from an O-1 visa meant to be temporary to a permanent residency process? So the short answer in this question is yes, with some caveats. So the O-1 is a non-immigrant visa, therefore it is a temporary visa. When you get the O-1 visa, and when you enter the U.S. in the O-1 visa, you are supposed to have, you must have a non-immigrant intent in the United States. You must plan to, you must not have a plan to stay here forever. You must plan to stay here temporarily until your itinerary is done or what have you, and then return to your home country, or at least leave the United States. Having said that, if your intention changes after you get here in O-1 status, it is possible to then transition to a green card, to permanent residency. But again, you really need to make sure that you have a non-immigrant intent at first, and if you're here as on the O-1 and then you get a permanent job offer, you're with the company and they say, we love you so much, we want to stay here forever, we want to sponsor you for a green card, it is possible to then start the adjustment of status process to try to get a green card. Then there are some issues that would come up in terms of when you're going to file and maintaining your status, and inability to pursue international travel comes up at a certain point. So yes, that you can pursue the permanent residency process, but it's something that you want to look at carefully, and you want to examine timing issues and depend on the specifics of the situation, but is possible. My pleasure. My pleasure to be here with you all today. And again, I'll give it another 1 minute, and if there's no other questions, we'll end it for now. Okay, it looks like that'll do it. I hope I've given you some good general information that you'll find useful in considering whether or not you're going to apply for an O-1 visa. Please do, again, feel free to contact my firm or myself if you like more specific, if you have any more specific questions you'd like answered, or if you want us to kind of evaluate a potential case that you may be considering. I hope you all have a wonderful afternoon and that we have a chance to work together in the future.